Good afternoon, everybody. Today we have our speaker, Mr. Swaroop George. A very warm welcome to you, sir. Swaroop George is a managing partner at Law Green, which is a full-service law firm based out of Delhi. He heads the firm's commercial litigation practice and appears regularly before the National Company Law Tribunal and Appellate Tribunal and High Court of Delhi. He has been involved in litigation which touches upon various aspects of commercial law, including international commercial arbitration. Over the period of time, Mr. George has gained expertise in cases dealing with the insolvency and bankruptcy code since the inception of the code. Mr. George also has to his credit a master's degree in the field of international dispute resolution from the University of London International Programs. He's a young, dynamic lawyer, and we welcome you, sir, on this board for throwing light on the topic of petitions to be filed under Section 9 of Insolvency and Bankruptcy. Thank you so much.
Right. Thank you so much for having me here. First of all, so the present webinar is about filing of Section 9 petition and the applicable issues. So we'll be having an overview of the entire procedure, right from the sending of the demand notice to the actual filing of the petition and the adjudication thereof. So coming to the, let me just share the PPT. Right. I hope the same is visible, right? Right. So the first thing that you need to keep in mind while filing the section, while wondering whether to take recourse under Section 9 of the Insolvency Bankruptcy Code is that Section 9 is applicable to operational creditors. Now, first question is whether your debt is coming under the category of an operational debt, whether you are an operational creditor or not. Now, the code defines an operational creditor as a claim in respect of the provision of goods and services, including employment or a debt or any due which is payable to the government under any law in force. Now, so basically what it means is that if you're selling any goods or services and you have not been paid for the same, you will be falling under the category of an operational creditor. Now, an operational debt would not include any claim by the purchaser of any goods and services. Like, for example, if they are asking for a refund. Now, this was actually made clear in a couple of cases where before flag buyers were included as financial creditors, flag buyers had opted to go under Section 9 as operational creditors. So the NCLT in Colonel Vinod Awasthi and other cases had said that unless there is a supply of services or goods by the person purporting to be claiming to be an operational creditor, they will not be categorized as an operational creditor. The second aspect now is whether a lease of an immovable property would come under an operational creditor, because one of the arguments was that you're providing a service, and even the Banking Law Reforms Committee had also given an example of a lease as a category of an operational debt. But the NCLAT held that in the final act, this had not been incorporated. So with regard to a lease of an immovable property, this will not come under a category of an operational debt. This was held in Ramindranath Reddy versus G. Kishan. Now, of course, these NCLAT judgments are subject to review by the Supreme Court, because it has happened in the past as well that the NCLAT has laid down certain principles of law, and this has subsequently been reversed by the Supreme Court. So we'll have to wait for the final decision by the Supreme Court. Now, in the Flipkart, Neeraj Jain versus Cloudworker Streaming Technologies, this was the judgment setting aside the insolvency of Flipkart. The NCLAT held that any damages or losses which are not being crystallized, they will also not fall under the category of an operational creditor. So crystallized means that, for example, if you're asking, if you're claiming that the buyer of goods or services has committed a breach under the contract, but the damages are not quantified. For example, if you're selling certain goods, but the goods have not been taken over by the buyer, but you are saying that the act of not taking over by the buyer is a breach of the contract. Now, in such a case, the damages may not be quantified. So the NCLAT said that the NCLT in its truncated procedures cannot go into evidence and cannot examine and detail what will be the actual claim amount due to you. So of course, if they're taken over the possession of the goods and you raised invoices and the invoice has not been paid, these are crystallized debts and you can go under Section 9. Now, another aspect that needs to be considered is whether interest forms a part of the operational debt. Now, first of all, what the NCLTs have been doing is that unless there is an agreement specifically stating that you are entitled to interest for any delay in payment or a delay of provision of services or something of that nature, no interest would not be payable under the general law as such. I mean, arguments have been made that, of course, delay in payment has caused loss, so interest has to be paid on that. But the NCLTs have not been rendering companies insolvent solely on the ground if there is not an agreement to the effect, only for the interest component. Now, another issue with regard to interest comes in the case that the NCLAT has held that if the principal amount has been paid, now if you're only making a claim for interest, then the same would not be maintainable. Of course, if you have a principal amount, then you can always claim interest along with it, and it's advisable as well for two reasons. Firstly, in section 9 petitions, a number of times the cooperator will come and negotiate with you. In such a case, having the claim for interest as well will be a boon in your negotiation. Another aspect is, even if your section 9 case is dismissed, you're always free to offer other remedies like suits or arbitration or under the MSME Act, whichever is applicable. Because
Dr. Mr. George, I would like to stop you here. Please be little slow. I'm getting messages from the viewers. A little slow, please. Thank you so much.
So with regard to the interest component, it's always advisable to put in certain amount of interest as well, because it's beneficial when it comes to the negotiation aspect. Because because whenever section 9 is filed, especially if you are likely to win the case, the cooperator is likely to engage in negotiation talks with you. In such a scenario, having the claim of interest as well is a boon to you when you're negotiating. Another aspect is, if your section 9 case is actually dismissed, or if your section 9 case is dismissed, then the NCLT, what it normally says is that in our limited jurisdiction we cannot admit this case. So most of your times your cases, you're free to pursue other alternate remedies, like in the nature of an MSME or your suit or whatever remedy is applicable to you under the applicable law. So in such a case, of course, that you can always raise the ground that you were claiming interest from the start. So there should not be any objection that you waived off interest or something of that aspect. Now, the first part of the procedure when you are actually opting to press your claims under section 9 is that you have to mandatorily send a notice under section 8 of the code. Section 8 of the code states that that you have to send a demand notice to the operational the corporate debtor, the company which has in debt. So in that case, you also have to give, after delivery of the notice, you have to give them a 10-day period. A 10-day period in which they can respond to you, raising whether there's been a dispute created with regard to the debt, as in why it's not payable, or that whether the amount has been paid back. So what has to be noted is, after the delivery of the section 8 notice, you have to wait for 10 days before filing of the petition. If you file it before, the NCLT may say that you have to wait for 10 days, and you may, in fact, the NCLT may also ask you to withdraw the petition and file it after 10 days. Now, it's important to be very careful when sending the notice, because the issue is, if you mess up the notice and you file a petition, then your case may very well be dismissed on that ground itself. And the second aspect is, even if you feel that you can just send a section 8 notice again, in the meantime they may raise a dispute. Now, with regard to what the defense regarding dispute is, I'll come to later on. But so it's very essential to be very careful when sending the section 8 notice. Now, there's certain particulars to be kept in mind. First of all, how is the notice to be sent and where is it sent? It can be under the code. It may be sent at the registered office, by hand, registered post, or by speed post. Now, the registered address you'll of course find in the master data of the corporate data company. Now, the master data is available at the Ministry of Corporate Affairs website. You don't even need a login ID or anything. You can simply take it from there. Or you can send it by electronic mail service to the whole-time director of the corporate data, or the designated partner or key managerial person of the corporate data. Now, the third aspect which the NCLAT has clarified is that you can even send it to the corporate office by hand, registered post, or speed post with acknowledgement due. Now, it's another essential thing is, not only do you have to keep the post receipt, as well as the tracking report. If the tracking report says it's not delivered or anything, that will cause complications for you. So it's essential to get the delivery done to make your case as secure as possible. Keep that postal receipt as well as the tracking report showing that it has been delivered at the right address as stipulated in the registered master data, showing the registered address, or whatever the corporate address is, showing the right delivery. Next aspect to be considered is when should a notice under the code be sent? Normally, before the coming into effect of the insolvency and bankruptcy code, what we used to normally do is was send a normal legal notice and just to test the waters. But now the difficulty is that if you send a normal legal notice and they reply to it, they may raise a dispute. Again, I'll be coming into detail with regard to dispute aspect later. But the problem is if they raise a dispute, the NCLT may reject your case by saying that there is a pre-existing dispute. If you, instead of sending a normal legal notice, if you send a section 8 notice, the advantage is that after the sending of the section 8 notice, any correspondence, any document that they file later on, that cannot be considered by the NCLT to determine whether there is a pre-existing dispute. So it's like a deadline. Once you send the section 8 notice, whatever letters they write, whatever correspondence they write, for the purpose of the NCLT, they don't need to look into that to determine whether there's a pre-existing dispute. So it's always advisable that now, especially if you're considering going under the code, before you give any other legal notice or even enter into a settlement talks or negotiation talks, because even in settlement talks, they may write an email saying that no, your work was shoddy, there was some dispute, so that's why we want to give you less amount or whatever. So it's better to send a section 8 notice first, then enter into settlement talks or send any other legal notice thereafter. So that won't affect your case. Another question that comes up sometimes is whether an arbitration clause or some alternate remedy will bar your case under the insolvency code. So insolvency code under section 238 says it has an overriding effect. It won't bar your remedy. So irrespective of an arbitration clause, you can always go under the section 9 against a debtor company who has an operational debt. Now, when sending the section 8 notice, there has it's not a notice that you can send in any format. There are two possible formats. Both these formats can be found in the application to Adjudication Authority Rules 2016. Now the rules itself, as well as the latest versions of the act, can be found in the IBBI website. Because these rules and acts almost keep getting modified every 2-3 months, so it's the IBBI keeps the latest formats available. If you don't have the physical copy with you, you can always access the IBBI website to get the latest version of it. So I just reproduce the form. You can just have a look. This is form 3, form of demand notice / invoice demanding payment under the insolvency and bankruptcy code. So basically, as far as possible, you should stick as close to the format of the given in the rules itself. So basically, you can just fill in the details, the name and address of the registered cooperator, name of the cooperator. Now the particulars of the operational debt. First question is total amount of debt, details of transactions, and the date from which debt fell due. Now this is self-explanatory. You have to just give the total amount of debt and the date from which debt fell due. And with regard to details of transactions, when I've seen, sir, when the client or the layman sends it himself, they give very bare bones descriptions. They say that this amount is due on invoice number so and so. It's better to give the at least as much details that that someone who is not privy to the transactions, that someone who's actually not been part of the sale of goods and services, that someone who reads the notice, he should be able to understand. I mean, of course, if a lawyer is sending it, he always gives in detail. But if sometimes what I see is when the client is sending it himself, so they just give a one-line descriptions that that is not exactly the best course. The second row, if you can see, is amount claimed to be in default and the date on which default occurred. Now, the normal cases, the debt as well as the amount claimed in default might be the same. But sometimes, for example, in a contract which stipulates that the total amount of debt, for example, if a settlement agreement is entered into, the total amount of debt may be agreed at 1 crore, but it may say that every 10 lakhs would be paid on the first of every month. So then depending on how many months have been passed, that only a fraction would be in actual default. So then you have to specify what is the actual amount in default and the date on which default occurred. And you have to keep in mind that the petition will be filed with regard to the amount in default only, because the rest of the amount may not have actually become due and payable. You also have to annex along with your notice a working for the computation of default in tabular form. So basically, you can make a table saying that this is the principal amount, it became due on this date, and you can make a separate table for the interest component as well, that at this rate of interest, as on up to this date, this is the interest coming up, along with further future interest that will be payable if you don't pay the same. And you can have it signed by the client and stamped by the client. Third is particulars of security held. Now, operation creditors may not have any security, but if you do have any security held against the debtor company, you should mention the same. Fourth, the details of retention of title arrangements in respect of goods to which the operational debt refers. Now, this is again factual. If your contract has any such clause with regard to retention and you have retained or something to that effect, you can mention the same. Fifth row is record of default with the information utility, if any. Now, information utilities are actually organizations which are set up where the client or the creditor can go and register their contract, and if in default occurs, they can register the default as well. But to my experience, 99% of the cases clients don't do that. I mean, because even the information utilities have been set up very recently. So even if that's not there, you can just simply say not applicable. But if it's there, you can put it as an additional proof. 6 is the provision of law contract. Here you can mention the contractual clause, and of course the claims will be payable under the Contract Act as well. 7th, list of documents. Any other document that you want to use to prove the debt, like the correspondence, etc., you can just mention and annex the same. Now this is again the standard format if you dispute the existence, so you can just reproduce the same and just fill in the blanks here. Para 5 is with regard to information utility. Again, if you're not actually registered with the information utility, you can just delete this para 5 and make para 6 para 5. In para 6, again, you will be asking them to make the payment in 10 days, failing which you will be initiating insolvency process. Now, here you'll have the signature of the person authorized to sign. If it's a counsel, the counsel signature, name in block letters, position, address of the person signing. And the instruction says, of course, 10 days in advance of filing, you have to send the same, and you have to append a copy of the served notice to the application. Now, when you are filing the application, not only the notice, and of course, the annexures have also been annexed, and the postal receipt as well as the tracking report. Because one of the first things that the NCLT does on the first date is that it verifies whether the section notice has actually been delivered or not. If you've gotten a reply from the cooperator, of course, then it can be assumed that it's been delivered. But in many cases, they don't reply. If they don't reply, then it's essential to take the NCLT through the NCLT itself will ask in many cases. It will ask you to show the postal receipt as well as the tracking report, and they do compare in many cases with a fine eye to see whether all the details are correct and it's actually been delivered at the correct address. Now, another format is Form 4. Now, this is a much more simpler format. There's not much to be done. Basically, the format is there and you have to fill in the blanks with regard to the name of the operation creditor, the amount, etc. So there's not much to be done. Only thing is that you need to annex the invoice. Along with this notice, you need to annex an invoice stating that, this is the amount due, this is the invoice, and that invoice needs to be annexed. Now, initially, parties were free to decide, in which format to send. So most of the times, lawyers used to adopt Form 3 because, there's more space given to put in detail your claim and etc. But the NCLAT in Flipkart has laid down certain guidelines to determine, now after interpreting the code itself, they laid down certain guidelines to determine which format is to be used when sending a notice. Now you have to either send it in Form 3 or Form 4. Now, the NCLAT said that, the operational creditor does not have a free choice to determine which format to send the notice. It depends on the nature of the operational debt. If your transaction is of such a nature that invoices are normally generated, for example, if you are, it's a works contract or, you're building something and, you're sending invoices. So in that case, invoices are normally generated. If invoices are generated, then Form 4, that is this format, form of notice, which is invoice demanding payment is to be attached, that has to be sent. If your transaction is of such a nature that invoices are not being generated, so this would be case if you are an employee. If you are an employee, obviously you are not going to be sending notices to your invoices to your employee every month saying that this is the amount due, there will be salary slips, etc. If there are no invoices, then you will be adopting Form 3. And you will be annexing the list of documents. So in this, you can annex your salary slips, etc. To prove your debt. So after Flipkart, now of course, this has to be tested by the Supreme Court as well. But after Flipkart, as of now, what the law says is that depending on the nature of the operational debt, as discussed, you have to send according to the correct format. Now, initially, there was an issue where certain NCLAT judgments had said that a counsel, for example, the person signing, as you can see at the end of the notice, you have to sign the signature person. So counsels will sign in their own name because they were the counsel of the operational creditor. Now, there are certain NCLAT judgments which said that, you can send it in the name of the advocate or the counsel. You have to send it in the name of the employee or the authorized person. Now, the Supreme Court in Macquarie Bank has made it clear that, even it can be sent in the name of the counsel itself. There's no bar to that. And that will not make your case unmaintainable only on that ground. Now, after you file the Section 8, you have to wait, once it's been delivered, you have to wait for 10 days. And after that, you can file under you file your petition asking that the company be rendered insolvent for non-payment of the debt under Section 9 of the code. Now, as per the application adjudicator rules, even when you're filing the case, you need to send a copy of the entire petition along with the annexures to the to the registered office of the corporate debtor. This you can do by registered post or speed post, etc. And while you don't have, you may just annex the postal receipt with your petition that you will send it the same. If your petition is being listed 2-3 days after the filing of the same, it's advisable, if the tracking report has been uploaded, to keep a copy of the tracking report as well, because the NCLT sometimes what it does is, it asks for the tracking report even for the dispatch of the copy itself as well. So keep a couple of photocopies of the tracking report if it has been uploaded with you, so that you can hand it over the bar itself. Now, another question is, who can file an application under Section 9 of the Code? So basically, any person can file a petition, including companies, partnerships, etc. The only issue might be if you're in proprietorship. For example, just like in suits, proprietorship itself does not have a legal entity. But you can get through that, get over that, just like in suits, by saying that, sole proprietorship through its sole proprietor, so and so. So you can make it that, it's actually the sole proprietor, that was the individual who is actually filing the same. Now, Section 9 petitions can normally not be filed jointly for multiple debts, but there is an exception when it comes to workmen or employees. Multiple workmen can authorize one workman to file the Section 9 petition. And now the Supreme Court has, in J.K. Jute Mill case, has also clarified that a registered trade union, it should be registered, a registered trade union can, issue demand notice and file Section 9 petition on behalf of its members as well. So if you're a registered, because that makes sense as well, because if every individual workman or employee is issuing notice and filing applications, not only would it cause huge burden on the NCLT, and the costs involved for the employees and workmen will be drastically more as well. Now, coming to the format of the application, again, you have to follow the format given under Form 5 of the Application to Adjudicating Authority rules. Now, I've seen cases where, sometimes counsels, file the petition in a normal, suit-like format. And, the NCLT has, asked them to withdraw their case and, file it as per the proper format. Now, the format, you can just have a look. Application by operational creditor to initiate CIRP under Chapter 2 of Part 2 or Chapter 4 of Part 2. Chapter 2 of Part 2 is the normal insolvency. Chapter 4 of Part 2 is for fast-track insolvency. Fast-track insolvency will only be applicable for certain categories of companies which have been notified by the central government. Now, the only advantage under fast-track insolvency will be only after the corporate insolvency itself is initiated. As far as the adjudication of the Section 9 petition is concerned, that will be a similar procedure for both types. Now, again, you just have to follow the format. You have to fill the details: the national complaint tribunal, address of the national complaint tribunal, the names of the operational creditor, name of cooperator, particulars of applicant. You can again fill in the same. Identification number, if you're a company, if your operational creditor is a company, you can give the company identification number, again available on the master data as per the MCA website. Or if it's an individual, you can just give an identification number, whatever ID they possess as well. Name of the cooperator, again, all these details you will find on the master data, which is available in the Ministry of Corporate Affairs website. Nominal share capital, details of guarantee, it's available as per the master data. And if there is any guarantee clause, something, you can mention the same. Address, now you have to submit the name, address, and authority of the person submitting application. So if it's a company, you will have to, there has to be a board resolution in favor of someone, to authorizing them to submit the application, as well as, to accept the service of process. You can make it two separate people as well, but that's not necessary as well. You can just give authorization for one person for both the purposes. Now, this row 8 is only for fast-track insolvency. If you're not going under fast-track insolvency, you can simply say not applicable. Not applicable. Otherwise, you can just fill in the assets and income, class of creditor, amount of debt, category of corporate person, as per the details of the corporate data. Now, I'll be coming to when to propose an interim resolution provision. Basically, an interim resolution provision is the person who is going to be taking over the corporate debtor company. He's going to be, he's going to be in charge of the management of the company. If your case ultimately succeeds and you push the company into corporate insolvency resolution process. Now, here you can just give the name, address, email address, and registration number of the proposed IRP. If you are not proposing an IRP, and which will be advisable in quite a few cases, you can simply say that the Honorable NCLT may appoint the interim resolution professional if the present case is admitted. Because even if you don't propose an IRP, the NCLT will on its own appoint an IRP if the case is actually successful. Now, particulars of operational, this is similar to the notice as we discussed. Particulars of, again, this similar to the notice, it has to be similarly filled in the row. particulars of, now if there is an order, a decree in your favor, you can attach a copy of the order. Again, record of default if it's available. Details of search and certificate, again, if the same is applicable, you can just attach the same. Provision of law, again, that's similar. Statement of bank account. Now, where in the bank account where you, for the particular transaction, you've been receiving amounts of money from the corporate debtor, for that particular bank account, you should attach the statement for the relevant period to show that what were the amounts being given and all. Any other documents you want to file, you can also file the same under row 8. Now, this para is of course only certifies that the proposed insolvency professional is fully qualified, etc. Now, this is only applicable if you are actually proposing an IRP. Now, you can again just fill in the details here. Now, some of the annexures that need to be annexed, apart from the ones already discussed, is just like in the notice, you have to give the workings of the default, the annexure, and the copy of the invoice and demand notice, along with all the annexures, tracking report, and the post receipt as well. Any other document, as of course, referred to in the form as well. If, for example, if you're referring to a bill or something, you should annex the same. And also, if you're sending a Section 8 notice and if you received a reply, it's important to annex the same, because otherwise, there'll be allegations that you're not coming with a clean hand, etc., etc. Then, copy of the relevant accounts from the bank's financial institutions, confirming that there is no payment of the relevant unpaid operational debt by the operational debtor if available. Now, most of the times banks are not willing to certify that the unpaid operational debt has not been paid. So in that, you can just simply ask the bank, and if they refuse, you can say you don't need to annex the same. There's been judgment of the Supreme Court to the effect as well that it won't bar your case provided you can prove the default by some other means. But it's better to just write an email or saying something, because if the NCLT asks you whether you actually ask the bank or not, you can simply say that, I asked the bank, but there has been either no response, or, they refused to do the same. Now, Annexure 4, affidavit. An affidavit has to be filed stating that no dispute has been raised with regard to the unpaid operational debt. Now, this affidavit has to be filed by the person, authorized to act on behalf of the operational creditor. Now, if a dispute has been raised, now I'll come to that later. If a dispute has been raised, then you have two options. Either you can, not file the affidavit in terms of Supreme Court judgment, or you can modify the affidavit accordingly. I'll come to that later. Now, another aspect is written communication. Now, Form 2 of the Application to Adjudication Authority Rules specifies the format for the written communication. So if you're proposing an IRP, you can just simply pick a name. The IRP has to give us consent, a written consent in the form prescribed with the declarations. And you will also have to, even though it's not mentioned, I've seen the NCLT insist from many a time that you have to give the annex the registration certificate of the insolvency professional as well, and it has to be attested by the insolvency professional as well. So both the written communication as well as the registration certificate of the insolvency professional and attested by the same. Proof that the application, now this, like any other litigation, proof of the payment of the same. Now, stages in adjudication. Now, if you not had an opportunity to actually, litigate a Section 9 petition, basically it follows a procedure very similar to a writ procedure. On the first date, you convince the NCLT of a prima facie case, they issue notice, and second date, ideally speaking, the other side appears, they take time to file a reply, and if needed, you get the time to file rejoinder. On the third day, they hear arguments. Now, of course, this is a very ideal situation. Many hiccups may come up. For example, on the first date, the NCLT may ask you to file certain additional documents before issuing the notice. Or on the second date, the cooperator may not appear, in which case the NCLT may ask you to, again, just for caution's sake, send a notice. And of course, when you, the notice in the procedure I've seen adopted by the NCLT, the notice will normally be issued by you, sent by you, and you will be filing an affidavit of service saying that, this has been delivered. Now, but the main thing to be kept in mind is that you only need actually 3 effective hearings, to get your case resolved. So this is one of the advantages of the Section 9 petition, why most of the cases are resolved in a relatively quick manner, because at the end of the day, even if adjournments are given for various reasons, provided 3 effective hearings are there, you should be able to, get your case over with. Now, under the Act, there was a timeline that, you have to dispose of the case within 14 days. But that has been held to be only discretionary. So your case will not be affected if it goes beyond 14 days as well. But if your case is being delayed for a long time, sometimes what people do is they file an appeal to the NCLAT, and so far the NCLAT has been willing to give orders that, that let the case be disposed of within such and such time, or as quickly as possible. Now, another issue that comes up is when to propose an interim resolution professional. Now, proposing an IRP has some hidden cost because I've seen that normal practice is that if you don't personally know the IRP, or the client doesn't know the IRP, is that IRP normally charges a signing fee for giving the written consent. Now, even if your case is dismissed, or your case is dismissed, or it never reaches the stage of insolvency as such, he'll probably take in advance the fees charged for written consent. That seems to be practice as of now. So that will be an additional expense for the operational creditor. And if it goes into insolvency, then he'll take more fees accordingly, but that's recoverable as CRP cost. But I'll come to that aspect later on. Now, in certain situations, you may actually consider appointing an IRP, because normally, even if you don't appoint an IRP, the NCLT on its own will be appointing an IRP. So the only advantage is if you feel that the company will not be able to settle, either it's not willing or it doesn't have the funds. Then in such a scenario, having a trusted IRP may be important, because the issue is if it goes into CRP, the entire process is overseen by a committee of creditors. Now, the committee of creditors, unfortunately for an operational creditor, is that an operational creditor will not form a part of the committee of creditors. Only financial, even if there is only one financial creditor, the financial creditor will be the person who will be forming the committee of creditors. Financial creditors are people who have given loans, who are given money for the time value of money. So normally banks, etc., form the committee of creditors, or by definition now flat buyers as well fall under the category of financial creditors. So in such a case, the problem is that the operational creditor will have no oversight of the process. And another problem is the main issue with regard to IRP is that the operator will have no oversight of the process. So sometimes what happens is, if a complete stranger comes in as an IRP, your operational creditor will have the IRP might even completely ignore the operational creditor as well, because his mandate is to report to the committee of creditors, which is constituted by the financial creditors. So in such a case, if you feel that it's going to push to the CRP and it's going to be a long-term process, you may consider appointing an IRP, but with the caveat that if the COC feels, then it can by voting remove your proposed IRP and replace it with some other RP. Court fees to be paid. Now, this is a fixed fee, so I guess that's another advantage of filing under Section 9. Only rupees 2,000, regardless of what the amount of debt is. Now, another question is territorial jurisdiction. Now, cause of action as such doesn't matter for when filing a Section 9 petition, nor does any agreement between the parties restricting any exclusive jurisdiction. It has to be filed within the with the bench of the NCLT, within whose jurisdiction the registered address of the corporate debtor lies. Now, so for example, if your registered address is in Delhi, it will be the NCLT Delhi. You can find on the NCLT website the various benches and their jurisdictions. So cause of action or any agreement contrary to by the parties will not affect jurisdiction. You have to file within as per the registered address of the corporate debtor. Pecuniary jurisdiction, initially it was 1 lakh. Because of the COVID-19 situation, it has now been increased to 1 crore, whether it's temporary or permanent, we don't know as of now. Time given. So another essential thing is, if your application is missing certain documents, or if there's something incomplete. Now the NCLT cannot directly reject your application on that ground. It has to give a time of at least 7 days to make your application complete to rectify the errors. Now initially the NCLAT was of the view that the 7 days is mandatory, and if you go even 1 day beyond that, your case has to be rejected. But the Supreme Court has clarified in Surendra Trading Company that even if you go beyond 7 days, as long as you file a written application showing sufficient cause that this for this reason we have not been able to clear the defects within 7 days, and provided the NCLT accepts that reasoning, that delay can be condoned. Now, as I was stating earlier, in the format it says banks have to actually certify that the unpaid operational debt has not been paid. The Supreme Court has clarified in Mercuria Bank that this is not a mandatory requirement. If you can prove by some other means that this default has occurred, there's even if you don't file the same, it won't bar your case as such. Now, when you're filing a Section 9 petition, what are the major defenses that you're going to be facing? So basically, there are 4 major categories that you can face. The first and major category, and this is actually the one which is raised by almost every debtor, is existence of a pre-existing dispute. Now, firstly, let's see what a dispute, how the code defines a dispute. The code defines a dispute as including a suit or as including a suit or arbitration proceedings related to the existence of amount of debt, quality of goods and services, or the breach of representation or warranty. So first of all, the question is, if there is a dispute, this is actually inclusive. So initially what the NCLAT was holding, NCLAT and NCLTs were holding was, if there is not a litigation as such, for example, if there is no suit or arbitration, you can't prove the existence of a dispute, and the cooperator cannot take recourse to that defense. The Supreme Court in Mobile Ox versus Kirosa has clarified that the scope of dispute is not limited to the existence of suit and arbitration, and it can be proved by other means as well. For example, through correspondence. If they write a letter to you saying that your goods were shoddy, your services were not up to the mark, that can be seen as an existence of a dispute. Now, the Supreme Court also clarified the scope of review by the NCLT. The Supreme Court clarified that the NCLT doesn't need to actually see the dispute and see whether this dispute is 100% correct or not. Only thing that the NCLT needs to see is whether it's a plausible contention, because the NCLT, as you've seen, has a very truncated procedure. It doesn't actually call for a recording of evidence, call for witnesses, cross-examination, etc. So within its limited jurisdiction, it can't actually go into detail. So only thing it needs to see is whether actually a dispute has actually been raised, which has some bona fides to it. Now, even if a dispute is raised, the counter argument to that is that you can say that it's a very patently feeble legal argument, or that it's it's a very spurious defense, or mere bluster to prevent the jurisdiction of the NCLT from taking place. It's a very, very narrow scope. So, for example, in certain cases where even if a dispute is raised, if there's a subsequent settlement agreement, duly registered and all that, you may be able to raise that objection. So as I was talking about earlier, you need to file an affidavit saying that no dispute has been raised. The Supreme Court in Macquarie Bank had held that if the dispute has been raised, then you don't actually need to file an affidavit, because a dispute has been raised. But another alternative is you can state in the affidavit that in terms of the Mobile Ox judgment, no dispute has been raised, which is not frivolous, patently feeble legal argument, etc., etc. But while filing the petition, it's advisable to keep those letters which are claiming as moonshine or just for the sake of raising of dispute letters, so that the NCLT so that there are no allegations later on stating that you have not come with a clean hand, because what you're taking is not a factual argument but a legal argument that this is actually not even a it doesn't even come to close to a plausible contention. Now, one of the crucial aspects of the Section 9 and the entire process is that the dispute must be pre-existing. Now, what happens in some of these summary, even there are other summary mechanisms available under other acts as well. But in the IBC, there's a peculiarity that the dispute must be pre-existing. Once you, as I said earlier, once you send the Section 8 notice, if they write 100 letters, if they file a case stating that even if they file an arbitration after sending of the Section 8 notice, that will not be taken as a ground to determine whether it's a pre-existing dispute. So the NCLT will not reject your application on the ground that there is a pre-existing dispute if this dispute is based on whatever correspondence or litigation after the sending of the Section 8 notice. That's why I said that before even entering into negotiation talks or sending a normal legal notice, if you are contemplating a path under the IBC, it's better to send a Section 8 notice before that. And even if you're not contemplating a path under the IBC, just the sending of the Section 8 notice can be useful in several cases because it puts pressure on the cooperator. And I've seen a number of cases that the cooperator actually being willing to settle even after sending of the Section 8 notice, because they realize that they don't have any correspondence showing any dispute as such. So it's advisable to send a Section 8 notice as soon as possible. Any correspondence or litigation they take after that cannot be taken by the NCLT to consider whether there is a pre-existing dispute. Now, if part of your claim is disputed, for example, if you're raising a claim of 5 crores and the other side has a letter stating that 1 crore is disputed, so in that case you can say you can claim the entire amount, and if they raise a dispute regarding only a portion of it, you can the law laid down by the NCLT as well as the NCLAT is, as long as the portion admitted, which is not disputed, is more than the pecuniary threshold stated under the Act, the company has to be rendered insolvent. So earlier it was 1 lakh, so it was much easier, but now it's 1 crore, so it's a bit more difficult now. Now, another question is, suppose you have an arbitral award in your favor. it will not, this will not, if there is a petition under section 34, section 37 of the Arbitration Act, if there's an appellate procedures of that nature, it automatically means that your petition is there's a pre-existing dispute, provided that, of course, that, provided that your claim is based on such an arbitral award. The Supreme Court had also clarified that, if the limitation period of filing of section 34, etc. had gone by, this argument may be raised before the NCLT, saying that, limitation period has gone by, now there is no ground for filing of the appellate proceedings. Another question that comes up is that, many a time, checks may be given, etc., to the operational creditor. If the operational creditor files a petition under section 138 of the NI Act, before sending of section 8 notice or before going to the NCLT under section 9, this the NCLAT has held that, existence of a 138 petition would not by itself constitute a dispute. So existence of a litigation under 138 will not automatically bar your case. Next aspect is, suppose you've gone under the MSMED Act. Now the NCLAT held in I-Value Advisors that the existence of a petition under the MSMED Act, there's a mode for statutory arbitration. So if you conciliation followed by arbitration. So if you started that process, it will not automatically mean a dispute unless they filed a reply or something to the before the MSMEs, or there's a correspondence or something stating that your goods are not up to the mark, your services are not up to the mark. If they not actually raise a dispute, the mere existence of a petition pending before the MSME will not itself constitute a dispute. The next category of defense that they may take is with regard to limitation. Now, earlier there was some confusion. There were some judgments saying that the Limitation Act would not be applicable to the IBC, but now the Supreme Court has made it clear that the Limitation Act would be applicable. It has held that the right to sue accrues when a default occurs. If the default has occurred over 3 years prior to the date of filing of the application would be barred under Article 137 of the Limitation Act, save and except in those cases wherein the facts of the case, Section 5 of the Limitation Act may be applied to condone the delay in filing such applications. Now, the Supreme Court has considered the petition in Section 9 to be an application. So, if there is something in the Limitation Act relating to suits, it will not as such apply. So that's why Section 5. As you may be aware, that Section 5 is not applicable to the suits, but considering that the Section 9 petition was considered to be an application, it was held that Section 5 may be used in appropriate cases. Another category, now this is rarer, is that a non-existence of a legal debt is due and payable. This would be, for example, if they say that they already paid back the money. If they paid back the money, of course, on operation will normally not file a case. Another category would be, for example, if there are is a group company, the company may argue that your transaction was actually with a subsidiary company and not with the parent company, or something of that nature. But this defense is used more rarely. Now, technical objections. Now, technical objections such as non-compliance with the format required. If your demand notice is not being actually delivered, if they're able to prove that the demand notice was not delivered at the correct address, it was delivered to some other address, non-filing of required documents, etc. The pecuniary jurisdiction is it's below the pecuniary jurisdiction, territorial jurisdiction, etc. These objections may be raised. Of course, if there is any objection regarding the format of your application under Section 9, then you will of course be given time of 1 week, and provided you can prove the reason for not clearing the objections within 1 week, further time as such. Now, we need to examine what should be the end goal for operational creditors. Normally, when you file a suit, and of course, you want the decree to come in your favor. But in a Section 9, if you win the case, what happens is the company is pushed into corporate insolvency resolution process. Following that corporate insolvency resolution process to its logical end would not be advisable for an operational creditor. Why is that? Because there are a couple of reasons. Firstly, if you push it into corporate insolvency resolution process, all the creditors will be called, and the goal of CRP is to have a resolution with all the creditors. This will take from anything from 6 months or around 6 months to several years with appellate proceedings going on. So the payment due to you would be delayed for a long time. So that will cause more damage to you. Secondly, and even more importantly, as of now, the operational creditor has a lower priority for recovery of debts than financial creditors. So as I stated earlier, the committee of creditors is comprised of solely of financial creditors. Now they are overseeing the process. So what happens in CRP normally is that they try to sell the company as a whole, and from the recovery they distribute between the creditors. Now, if your company is actually going into CRP, if then the company may not have assets to pay off all its creditors at the same time, because normally the payments will be staggered, etc., etc. So if you're not able to pay off your creditors at the same time, then even the assets may not be enough, especially when you're selling in a CIP process. Anyone who's coming in to buy the company will be trying to get it at a discount. So if the assets are only 50 rupees, hypothetically speaking, if the assets are 50 rupees and the debt is 100 rupees, the creditors need to take an overall haircut of 50%. Now the problem for operational creditors arises in the fact that operational creditors have a lower priority for recovery of debts than financial creditors. So the financial creditors may, accept an bid offer from any person who wants to take over the company, stating that, if 50% haircut should be taken, financial creditors will only get a 10% haircut, while operational creditors will take a 40% haircut. Now, in some cases where, the assets are very low or nil, there have been resolution plans where, operational creditors can get less than 10% of their value, and even less as well. Now, initially the NCLT had been intervening in such cases, but now the recent judgments of the Supreme Court have held that the commercial wisdom given by the Committee of Creditors has to be given paramount importance. So right now it's very difficult for an operational creditor to challenge a bid by someone who wants to take over the company by simply stating that I got a lesser percentage of recovery than a financial creditor. Of course, it's subject to further evolution of the jurisprudence as well. But as of now, if you actually decide to push the company into CRP, right up to the end, there's a good chance that you may be only recovering a fraction of your operational debt. Now, another aspect that you need to consider is, because the initial CRP cost, like for example, as soon as the petition admitted, the IRP has to publish in the newspaper that this company has been insolvent, etc. So for the initial CRP cost, the NCLT, I've seen in recent orders, sometimes ask the operational creditor to make a deposit of 1 lakh or 2 lakh or whatever, so that the initial CRP costs are covered. This is of course recoverable. This is recoverable at the highest priority, even over the debt to the financial creditor, whatever costs are incurred in the corporate insolvency resolution process. So you will be getting like this amount for certain, but only question is it may be delayed again, because until the end of the process, until the bid is approved, the resolution plan is approved, the disbursal of the amounts may not start. Now, so as far as possible, operational creditors should be trying to settle the matter, because if the corporate debtor company is actually a bona fide company, and this happens in several cases as well, because even if a company has several assets, it may be simply trying to delay your payment, or it may be trying to get out of paying you. So in such a cases, especially it's very advisable to enter into a settlement agreement with them. You can you ask for the entire amount and just settle the same. So there just certain points to be kept in mind while settling. The advantage of settling, of course, is you get the entire amount. No need for waiting. You can just get the entire amount as soon as possible, or as per the schedule agreed in the settlement agreement. Now, first question that arises is that when can you settle? Now, anytime before the actual judgment declaring the corporate debtor company as insolvent, you are free to settle. There is no question about that. After the company is rendered insolvent, until the committee of creditors is constituted by the insolvency resolution professional. So, insolvency resolution professional, what he or she does is, he publishes an advertisement asking for the claims by the creditors, and then he constitutes a committee of creditors. If there are any financial creditors, it will be constituted by the financial creditor. Now, until the committee of creditors is actually constituted by the resolution professional, the Supreme Court has held in the Swiss Ribbons vs. Union of India that until the committee of creditors is constituted, the parties can approach the NCLT, and it can allow the withdrawal of the CRP process. So if you enter into a settlement agreement before that, you can approach the NCLT stating that under Rule 11 of the NCLT rules that that the CRP process may be withdrawn. And I've also seen people, what sometimes people do is they file the appeal in the NCLAT, and they annex the settlement agreement. So the NCLAT has so far been willing to give orders saying that if settlement is bona fide as such, what they do is they sometimes put a stay on the constitution of the committee of creditors, so that there is no bar to the settlement. If the COC is formed, then the operational creditor by himself or herself cannot take the company out of the CRP process. And of course, in such a case, then the debtor company will also not be willing to settle the same, because it has gains no advantage, unless of course they're able to satisfy the COC that the CRP needs to be withdrawn. So in such cases, after the COC is constituted, the corporate debtor will also have to take consent from 90% of the COC by voting share. So as far as possible, if the corporate debtor is willing to settle, you should get the settlement agreement done before the COC is constituted, and file an appropriate application. Now, Another thing that you should be as far as possible as a good as a cautionary principle is that you should file the settlement agreement with the NCLT or the NCLAT wherever settlement agreement has taken place. But sometimes what I've seen is sometimes on orally counsel submit and they withdraw the cases. Now this might not be any harmful when the payment has already been delivered. But if you are contemplating a schedule, where future payments are to be made after the withdrawal of the case as well, it's better that the terms are filed with the NCLT as well, so that subsequently any dispute with regard to the terms etc. don't arise. Another thing that you should be careful about is that suppose after insolvency you're settling the matter, you should definitely include a clause saying that whatever costs have been incurred in the CRP process by the RP etc. this should be paid by the corporate debtor, because sometimes because there is no strict guideline that when the NCLAT or NCLT settles the matter, that the costs have to be borne by the operational creditor, the corporate debtor only. So in some cases the NCLAT may actually may order, NCLAT or the NCLT may order that the operational creditor may pay for whatever reasons, maybe that they're not convinced with the bona fides with the operational creditor or whatever. So if that is if you feel that you should make sure that there is no risk, you should incorporate a clause in the settlement agreement saying that CRP costs have to be paid by the corporator, whatever be the amount. If you don't do that, and if God forbid the NCLT or NCLAT passes an order, the operational creditor has to pay the debt, then it causes chaos, because the RP will come and claim against you, and depending on how long the CRP process may come, and it may be a substantial amount. So to avoid that, you should as far as possible incorporate in the settlement agreement itself that it has the CRP costs have to be paid by the corporate debtor. Now just have a quick overview of the pros and cons of filing a petition under Section 9 of the code, as in why you should consider filing or not, and because you should not file a petition under Section 9. As I already said, it's a very truncated procedure, very similar to a writ procedure, that only 3 effective hearings you actually need. It's a quick remedy, lower cost because there's a fixed court fee, so it's not like a suit where depending on, of course, of the state as well, depending on the value of the amount, the court fees will increase. And even the truncated procedure means that normally it doesn't stretch on for so long, so the operational creditor will not have to pay more fees as a result. Third issue is there's enormous pressure on the corporate debtor to settle the dues. Now, unlike in a normal decree, for example, if you get a money decree stating that the debtor has to pay money to you. Now, at the end of the day, the corporate debtor can calculate that suppose I delay the payment, that suppose let me go into appeal, let me go into execution, let the process go on. So it can calculate that the maximum loss that it will suffer is whatever the decretal amount as well as whatever the interest has been granted. But when the company has been rendered insolvent, the directors are became directors of the corporate debtor company became subservient to the RP. Now this is very unbearable for directors. From my own personal experience, the directors feel very aggravated, because the RP comes into the picture. He looks over all the records of the company. If the company is not being run in a proper manner, that's even that may give rise to further complications. Or and the RP will also ask the directors to provide documents, etc., etc. So this causes a huge burden on directors. So what they want to do is settle the matter as quickly as possible, and or set aside the insolvency by whatever means are at their disposal. So this can be to the extent that for example, when I was on behalf of corporate debtor, which I'm rendered insolvent, directors were traveling to Delhi to attend every hearing of the appeal being held before the NCLAT. And every time there was an adjournment, they would come outside the courtroom and express their express their worry, because insolvency was getting dragged down. And especially if you're a public listed company, the share price will drop. So your claim may be 1 crore or 2 crore, but the actual costs of this CRP, the actual damage to the corporate debtor company is maybe much more than your actual claim amount. So this puts enormous pressure, and even the NCLAT has so far been very circumspect in granting stays to the NCLT orders admitting insolvency. It may issue notice, but in 90% of the cases, it does not grant a stay. So it provides a very strong incentive for corporate debtors to settle the amount. Another aspect is pre-existing dues. As discussed earlier, if there is no correspondence, or if there is no document to show that there was a dispute before sending on Section 8 notice, they can subsequently come and say, hypothetically speaking, that in this contract there were various obligations by the creditor, and you did not fulfill these obligations, and they can't file any affidavit of witness or any documentation after that deadline of Section 8 notice. So this actually restricts the scope of the NCLT's adjudication as well. So it can actually make it impossible for the corporate debtor to escape its liability, because once a Section 8 notice has been sent, and if they not raise a dispute, after that their hands may be tied, even if they decide to take any legal remedies. Cons are, of course, if you think that the case will not be settled as an operational creditor, as I've already said, there are various cons to pursuing CRP process as such to the end. So if you actually go into CRP process, then the pros such as quick remedy and lower cost, they will go out of the window. So, and yeah, even the recovery of your claim as such may be restricted to a very small percentage. And of course, if a dispute has been raised, if already there's an arbitration pending or a suit pending, then of course, your case may not be maintainable, provided you can exactly prove that it's a moonshine or something like to that effect. Your case may not be maintainable. And another thing, this happens in rarer cases, is if your client is dubious or something, if the case is actually very shaky, and but suppose you get an NCLT order in your favor ending the complaint to insolvency, but in appeal before the NCLAT, if the NCLAT feels that your operational creditor has not acted in a proper manner, your case was slightly fraudulent or something, then it may direct that it may impose costs firstly. It will of course set aside the CRP process. It may impose costs, and it may also direct that the CRP cost be paid by the operational creditor. Now, I've seen sometimes appeals pending in the NCLAT, for even for a year as well. So if during that year CRP has gone on, then cost may be really staggering. That will have to be paid by the operational creditor, and then you'll have to get into litigation with the resolution professional, to see what is the amount to be worked out. So this is basically the brief overview of the entire procedure. So if there are any Nitesh sir, if there are any questions or anything to that effect?
Shivani, can you hear me?
Yes, sir, I can hear you now.
So take up the questions which are there.
Definitely, sir. Thank you so much, sir, for this enlightening discussion. There are a couple of questions here.
Yeah.
By Advocate Nisha.
Yeah.
She asked, the limitation of 1 lakh has been extended to 1 crore. Is it retrospective?
Yeah, but now that's a question for. Firstly, the NCLT Kolkata in a recent judgment said that for pending cases it will not apply. But now there are two other issues. For example, even if you file a pending case, and I think the NCLT has taken a very correct view that that for pending cases, of course, once you actually filed the case, paid the court fees on the basis that jurisdiction is there, and even the amendment itself does not say that it will be retrospective. So for pending cases, I think right of the Supreme Court, it will be held that that it will not be retrospective. Of course, that's my opinion. And another thing to be considered is when the home buyer's amendment, that when certain amendments were made with regard to the status of to the home buyer, how they can file petition to the financial creditors. The amendment was very clear that said that it will be applicable to the pending cases, and it's under challenge, of course, before the Supreme Court. But it was very clear. But this amendment does not say at all that it will be applicable to pending cases. But two more issues remain. For pending cases, I think it's very clear. I think right up to the Supreme Court, it won't apply on pending cases. But suppose you send a Section 8 notice. Now, an argument can be raised that you can't actually file a case in terms of the court without sending the Section 8 notice and waiting 10 days. So now the question will come before the NCLT is that if you file a Section 8 notice before the amendment actually took place, have you actually initiated the legal procedure, and would the application of the same would it be a retrospective effect or not? Now that's, of course, to my knowledge, this has not been adjudicated by any NCLT so far. So this we'll have to wait and see to know how the jurisprudence evolves. And as far as, of course, cases where no notice has been sent, then maximum what an argument could be made is that the default took place before the amendment, so it should not apply. But that's, of course, a bit that would be a harder argument to take. So with regard to pending cases, I think it's pretty clear that it should not be retrospective. With regard to Section 8, those cases where Section 8 notice was actually sent before the actual amendment, or where the default has actually been done before the amendment, that we'll have to actually see how the NCLT and the the courts interpret. It's arguable on both sides. Yeah.
In the continuation, she asked that is the extension still applicable if Section 8 notice has been served by the operational creditor? Is there any format to reply the notice sent by CIRP to any creditors of the company?
Firstly, as I said, Section 8 notice, there's an arguable point that, you initiate the legal procedure and, it's not a case that you can file a case without actually sending the Section 8 notice. So this is an arguable point, but of course the counter argument might be that, suppose someone sends a Section 8 3 years ago. Now, will he still not be stuck by? This is something that the NCLT has to be taken into consideration. With regard to notice with regard to notice for CRP, actually the notice may be of multiple types. If you are asking about a notice sent under Section 8 to you, then there's no particular format. You can simply raise a dispute annexing any correspondence prior to the Section 8 notice was delivered to you. You can refer on those correspondences to state that there's a pre-existing dispute. And if you're talking about any notice by an RP and all, when the RP invites the claims from the creditors, there's a specific format that you can find under the rules to the code. But for general communications as such, there is no format as such.
Another question. Yes, there's another question from Advocate Nisha only. She asked, notice sent by CIRP to debtors. She's asking this question.
Notice sent by CIRP. So you are referring to an, I'm assuming by CIRP, you mean by the RP, while he's conducting the CIRP proceedings, he's sending a notice to debtors. Now, there is no specific format. There's no specific format to reply to the same. If it's to a debtor, if you are asked to submit your claims, then there is a specific format, but there's no specific format to saying that, that this debt is not due and payable.
So that was it. There's no further questions now.
Swaroop, I have one question.
Yeah.
So once whether a corporate or a company which is a tenant in somebody's or a private individual's premises, it went into a liquidation and then go before the insolvency court. So does they come out of the insolvency by saying that they are the operational creditors and they would not pay the rent of those premises, like the lease part which you stated in the beginning of your webinar today?
Yeah, once the CIRP process is actually initiated, then regardless of the nature of debt, the company has to pay those debts. For example, once the CIRP is initiated, the RP published a notice in the newspaper asking for all categories of creditors to submit their claim. Even if you don't fall under financial creditor, operational creditor, you can submit your claim provided there is a debt. So once the CIRP is started, you don't need to fall into a particular category. Now, once the CIRP is started, the principle says that for the you can't force, when the company is under CIRP, you can't force someone to provide services to you without payment. If they're making payment, you can't evict the company. But if they don't pay payment during the CIRP process, then you can approach the NCLT and evict the same. But if payments are made, you will have to continue with them as a tenant in terms of the agreement if the payments are made.
So would that mean, or we take it from that these landlords would not fall within the category of operational creditors?
Yeah, in terms of the NCLAT judgment, as of now, that's the status. Provided that the Supreme Court upholds the same. As of now, for an immovable property, for a lease or something to that effect, it won't fall under operational creditor. But as I said, once the CIRP is started, anyone can submit their claims. It's not restricted to an operational creditor or financial creditor.
Okay, thank you so much with this, Swaroop. Over to you, Shivani, for the thanking note to Swaroop.
Yes, I thank our speaker, Swaroop George, sir, who took out time to speak to us on a valuable topic, that is filing of Section 9 petition by an operational creditor under the Insolvency Code 2016, the applicable process and issues to be kept in mind. It has been a very insightful and enlightening discussion. On behalf of our team, I thank you, sir. We would also like to thank our learners for being actively participating and putting across questions of immense value. And lastly, I would thank Nitish sir, Hitakshi ma'am, for making this present webinar a success.
Thank you so much, Shivani.
Thank you so much, sir.
It was a wonderful.
Thank you, Nitish sir.
And thank you, Swaroop, for giving such an informative lecture today on this Section 9. Though it is a very technical subject, you have made it easy for all of us to understand. You know, many of the viewers are asking me about the PPT. I will definitely share with them the one which you have shared with me. Thank you so much for the same. And I think it was an insightful and delightful experience of us to hear you today. Thank you so much.
Thank you, sir. Thank you, sir.
Thank you, sir. Thank you.